Hey, I'm Jennifer Moore. I'm here with Matt Marcellino of Marcellino and Tyson, and we are back with our podcast talking today about discovery methods. So you hear your lawyer say, I'm going to issue some discovery, and we know what that means, but our clients don't really know what that means. So that's the purpose of today, kind of explaining briefly what that means and why we do it.
Right. It typically comes up like this, right? I need information from the other side, and I need it now. Right? And then the response is, okay, we'll issue some discovery, or maybe we'll issue a subpoena, which is also a form of discovery, right? And they're like, what's discovery? Well, it is what you're asking for. It's just a name that we use, right? So like in North Carolina, there's interrogatories, which is a fancy word for questions. They're written questions. You got to be careful with those, right? You only get 50 in total. So you can issue as many times as you want, as long as you don't exceed 50.
And we lawyers love to get real nitty gritty about that, because
Yes.
if you have a question and it says this is question number 24, but then it has about 10 sub-questions, then I'm going to call that question number 34
That's
and
right.
move on.
Yep.
So yeah, we can get a little strategic there.
Yep.
Yep.
And then so interrogatories would be questions like identify any person that has knowledge about the lawsuit, right? And then what does that person know, and what is their contact information? You have to, Jane Doe knows X, Y, and Z, and here's how you can contact her, and that's the response. But at the end of interrogatories, the person that is answering the questions also has to verify them, which is like an affidavit. They swear that they're telling the truth. It's notarized. But again, you only get 50 of those, right?
Yes.
Interrogatories in family context, we don't. I don't think we hit 50 often, right? It doesn't. We probably get into the 30s and so forth because, well, for you, maybe we do this differently, right? And I just smacked my thing. That's okay, right? Here it's right there. But
I hope so.
but here's the thing. So interrogatories can be used as, for me personally, like what I typically try to do is I get basic information out of the interrogatories, and I'm only really going to be using this for depositions, which we'll get to later, which is also a form of discovery, right?
Yep.
But another form of written discovery, which you can send as many as you want until somebody says you're harassing them,
Yes.
right, is request for production of documents.
Right.
And we use those a lot in family law, right?
A whole lot, yeah. So I guess let's back up. What we're talking about is a written discovery. So there's three kinds: interrogatories, requests for production of documents, and requests for admissions. So we've just told you about interrogatories, so now we're going to talk about requests for production of documents, and that's exactly what it sounds like. I'm literally asking the other side to give me certain documents, and I usually try to go back a couple of years, get everything I could possibly need to see where, really it's where the money's going. That's a big purpose of that. What kind of evidence the other side has against my client, or to support an allegation or disprove an allegation. It's to educate ourselves on the entire case and get what they have.
That's right. Documents is bank statements, credit card statements, mortgage statements, photographs, videos. It can be electronic data.
A big one.
Right. It's a ton of stuff.
Income, tax returns, pay stubs,
right.
All of that. Yeah. Deeds, appraisals, stuff you wouldn't think you would need, but you need it.
Right.
So, yep.
But that's how you get the information that typically the client's looking for.
Right.
More often than not, it is a money question.
Yes.
Right. Or an asset or a debt question.
Or knowing what's going to pop up in a courtroom.
That's also super helpful.
Yeah.
Right. So, and then you quickly refer to supporting or denying an allegation, right? So,
yes.
So if we're issuing discovery, that means someone has filed a lawsuit, right?
Yes.
Because otherwise we really can't be issuing discovery. There's some circumstances you can, generally not. But you're issuing discovery after a lawsuit's been filed, which means somebody has filed a complaint against you, or you have filed a complaint against someone else. And in that complaint it says, I allege you did X, Y, and Z. So you might send discovery to me that says, produce any and all documentation that supports your allegations 1, 2, 3, and 4.
Yep.
Right. And obviously that's to either help them prove their case or disprove their case.
Right.
Yeah, so you can get prepared.
Yeah.
Discovery is all about trying to discover information so
Yes.
that you can avoid those gotchas or
Right.
those
No gotcha moment in a
surprises at court.
Yeah.
So much fun.
Yes.
Right?
And then the third one is request for admissions. And so that is asking somebody to admit or deny the truth of a statement. So your name is Matt Marcellino.
Denied.
Admitted. Sometimes you want to say denied.
Right.
But yeah, so that's the type of That's the type of question. And I like using those depending on the case, because those, if you don't answer them on time, they can be deemed admitted. Now listen, family court's the wild, wild west. So sometimes we abide by that rule and sometimes we don't. But theoretically, according to our rules, if you don't admit or deny them within the time frame, they're deemed admitted, which is helpful.
It's essentially a conclusive, established fact, right? It's a stipulation, and the court has to consider it. They don't have to use it, right? But they have to consider it. It has to be part of their consideration.
So there's some strategy in what you issue, how you issue it, what you get back.
That's right.
Yeah.
Yep.
So there's your written discovery. Then you mentioned subpoenas.
Yeah, but how quickly do you have to respond to all this discovery when you
Good point.
get it?
We should talk about that. So it's 30 days, but you can extend your time to an extra 30 days.
Right.
So a total of 60 days. And then if lawyers are working well together, sometimes they send an email that says, hey, can I please have a quick extension, on top of my 60 days for like 2 more weeks? And that really means that my client hasn't got me everything I've wanted and I'm working really hard to get it. Please bear with me.
Yes.
And generally, you have a nice person on the other side who says, yeah, sure. So.
Yeah, I mean, I have to ask for informal extensions frequently. Sometimes it's because I'm not getting the documents I'm looking for, right? And it's also just because we have so many other cases, court hearings, mediations, depots, and so forth, where it's just like, man, I just can't get to it. And luckily, the camaraderie amongst most family law attorneys is pretty easy, so you can get that extension.
Yeah.
Right. But then the subpoena, I think you brought that up.
Yeah. So, sometimes, especially in a family law case, there's so much distrust between the parties, and so we can issue this, written discovery, but somebody says, I know he has bank accounts in, I don't know, Timbuktu, and I want to find out where. And so you can throw out a subpoena to a bank and make sure that what you're getting from the other side is truly what's all out there. Sometimes I'll just subpoena every bank in town that I know I can get stuff from, just to make sure that I'm not missing something.
Right. So subpoenas are sent to non-parties.
Correct.
Right?
Non-parties to get documents.
That's right. So banks, witnesses, companies, and so forth, right? So, and typically when you're issuing these, it's more often than not for bank statements, but it's also, if you ask in discovery, please produce the following. And the person's response may say, I don't have that within my care, custody, and control.
Right. And
so I can't give it to you.
Yeah.
But we know it exists, but they'll identify where it is and say it's a P&L or a balance sheet at a company that's not a party to the action. Yeah. You send subpoenas to that third party trying to get that information.
Yeah, or like in the context of a custody case, therapy records or school records or doctor's records. Sometimes it's hard to get those, like your client can't get them, or you need to get them in a way that's admissible in a courtroom and you need a custodian affidavit.
That's right.
We'll put a pin in our thought about explaining what a custodian affidavit is maybe in another one. But anyway, there's reasons why you would subpoena information as opposed to getting it directly from the other side.
Yeah, and they're used frequently.
Yes.
Probably far more than the other written discovery we were talking about.
Right, and again, we can't issue written discovery or subpoenas unless there's a lawsuit filed.
Correct, more often than not.
Yes.
Yeah. And then the last one, which I think is the most fun, depositions.
Yes, I love taking a deposition.
So depositions are not written discovery. It's not a subpoena. It's we're sitting in a room.
And I get to ask you anything I want.
Yeah, so I'd be sitting here with my client. You're over there with your client. If it's your deposition, you're deposing my client. You're just asking as many questions as humanly possible, trying to discover information that would either help or hurt your case.
And I don't want to give away all my strategies because I'm sure all of our opposing counsels will watch this video.
Oh, yes.
But there is a lot of strategy to a deposition, and the information that you get out of it is then put, like the person's testimony and your questions is put into a written transcript that's then usable in a courtroom.
Yeah, I mean, sometimes you're genuinely trying to figure out what's going on, and you're really trying to figure out and find information. Like, I don't understand what's going on. Please explain this to me, right?
Right.
There's that, and then there's the other side, which is I already know what's going on, and you might not think I do, so I'm going to ask you a bunch of questions to see if you lie to me.
Right. Yep. Right. That I already know the answer to.
Right.
And sometimes people get really frustrated when I ask them the same questions multiple times in different ways at differing times throughout the day, but there's a reason for it.
Yeah.
Yeah.
Yeah, you're right. There's so many ways to do it. You can, what I call shuffle the deck, right? Where the questions, instead of being like all together about one topic, you just sprinkle it all over the place.
I'm a sprinkler.
Right? Yeah. I mean,
dang it, I gave away one of my strategies.
I know, right?
Don't do this.
It's kind of how my brain works anyway, though.
Don't tell anybody. Yes, it is.
all over the place. So,
You said it, not me.
hey, I say it all the time.
Okay, so there's generally the methods of discovery. And I think the last thing that we should say is voluntary document production. So we've done a podcast about mediation and preparing for that, and sometimes mediating pre-lawsuit, or even like just resolving a case without a lawsuit. And if that's the case, then you're agreeing to exchange documents voluntarily. You generally whittle down what you need. You try to be, cut to the chase. And you usually are doing that if it's like not a super complicated case and you know what you need and you know that y'all can just get down to brass tacks.
Right.
So that's a good way of doing it if everybody's on board and trustworthy and approaching that in good faith.
Yeah, because in that circumstance, there's actually no requirement other than promise, right?
Right.
That they actually produce to you what you're asking for.
Yes.
So if they wanted to leave a few details out in their production, they can.
And a good lawyer, if you were resolving everything in that kind of a fashion, you haven't you haven't filed a lawsuit, you haven't done written discovery, you haven't issued subpoenas, a good lawyer in your settlement agreement will put some kind of language in there about this is based on voluntary production, and if something is left out, then it's a material, term to the contract, or if it's an asset that's left out, then you can go after that later, things like that.
Yep.
So hire yourself a good lawyer.
That's right.
Yeah. Okay.
All right.